It's okay. I can wing it. Do you have an agenda? It's all right. Just put yours here and I'll wing it. I'll call us to order. And first order of business is Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And if everybody who's going to give testimony today, if you stand or remain standing, whichever your condition is, and raise your right hand. Do you all swear or affirm the testimony you give us the truth, the whole truth, and nothing but the truth? It's okay. It's okay. As long as she swears, she doesn't have to stand. It helps me identify who is swearing in. I saw her. Thank you. For those who haven't been here before, my name is Drew Smith. I'm the Code Enforcement Special Magistrate for the City of St. Cloud. I am a practicing attorney. I've been doing local government law for about 20 years. I am not an attorney for the city. I am hired to be an independent fact finder, so my role is to hear both sides of the case, and then I will enter a verbal ruling today after all the evidence testimony has been heard. That will be followed in the mail by a written order. It is the written order that you will rely on. Any time limits that I give today will be based on that written order, but the written order will conform to my verbal rulings today. The order of each case will be the Code Enforcement Department will present its witness and their facts and testimony, and then after they're done with that, the respondents will have an opportunity to ask any questions they may have of the Code Enforcement Officer or of any witnesses of the city, and you'll also have the opportunity to present to me any evidence testimony you would like me to hear and consider. And when I've heard all the evidence testimony, like I said, I will enter that verbal ruling. And with that, I believe you can call our first case.
Case number 2021-2658, Investment One USA, Inc., owner, location of violation 722 Illinois Avenue, St. Cloud, Florida.
Good afternoon. Alex Miller, Code Enforcement Officer for the City of St. Cloud. I'm presenting the case for the property located at 722 Illinois Avenue. At this time, I would like to enter into evidence the following items: copy of the notice of violation, copy of the notice of violation sent by regular mail, copy of the notice of violation sent by regular mail posted at the property in City Hall, copy of the statement of violation and notice of hearing sent by certified mail posted at the property in City Hall, copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, copy of the code sections and violation, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $219.66. The respondent is here, and I have provided with the copies of the evidence. On December 20, 2021, Code Enforcement received a complaint about work being performed at this location. After verifying that there was no permit on record, Supervisor Sparkman and I made contact with the handyman working at this location and requested that he stops working until a permit is obtained. The handyman called the owner, who stated that they will obtain a permit. 7 working days were given to correct the violation. Access to the inside of the property was denied, but we were able to verify that plumbing and electrical work were being performed. 6 pictures were taken. On December 21, I received a call from the owner stating that she will allow us to do an inside inspection of the property. An appointment was scheduled for December 29. On December 29, 21, an inspection of the property was performed, and I was able to verify the plumbing, electrical, water heater replacement, drywall, framing, and windows were being performed prior to obtaining a permit. After the inspection, I spoke with the owner and explained that a permit for all the work will need to be obtained. She stated that she had COVID and will need extra time to obtain the permit. A notice of violation was sent to the owner and agent to correct the violation within 7 working days, and 10 photos were taken. On January 14, 22, I verified that an incomplete permit application was submitted on December 30th, 2021. The building department sends the contractor an email requesting the missing documents in order to process the application. I also made contact with the owner to explain what was going on, and she stated that she will contact the contractor to correct the application. A notice of violation by certified mail was sent to the owner and agent to correct the violation within 7 working days. On January 27, 21, I verified that a permit was not obtained and the property was still in violation. A notice of violation by regular mail was sent to the owner and agent to correct the violation within 7 working days. Posted the property in City Hall, did an affidavit of posting, and 1 photo was taken. On January 28, I received a call from the contractor stating that he was trying to help the owner obtain the permit, but not all the information was being provided for the application submittal because the work was performed by someone else, and he requested additional time to obtain the permit. On March 1st, 22, I verified that a permit was not obtained and the property was still in violation. A statement of violation and notice of hearings was sent to the owner and agent, posted the property in City Hall, did an affidavit of posting, and 1 picture was taken. As of March 11, I verified that a permit has not been issued and the property was still in violation. Early this morning, I checked and the permit has not been issued, so the property was still in violation.
Are you aware if any communications have gone on between the respondent and the building department on resolving the permit issues?
I know I just spoke with the contractor right now. He said the fees had been assessed today and he's just waiting to pay for the permit. He just told me right now, but
I'll let them testify
Yes,
to
sir.
it.
And I know there has been some communication, but they were waiting for the documents to be provided. It is the city's recommendation that the respondent be found in violation of allowing construction of repairs and alterations at the property prior to obtaining a permit. The city will recommend that the respondent be given until April 1st, 2022, to obtain a permit, or a fine in the amount of $250 be assessed until compliance is met. The city will also request that the cost incurred in bringing this case before the magistrate in the amount of $219.66 to be paid within 7 days of the written order by the special magistrate. And this concludes my presentation.
Thank you. Respondent? If you'll come and, either one of you, I think, were both of you sworn? He was not, okay. If you're going to offer testimony, I'll swear you in before you offer any, so if you would like to, I'll go ahead and. Do you swear from the testimony you give us the truth, the whole truth, and nothing but the truth? Thank you.
Hi, I'm Craig Hackebill. I'm the contractor. She hired me. As of today, we submitted everything last night, from my subcontractors. It got approved today. They sent a monetary amount, but I guess it just has to be signed off by the chief building inspector. So as soon as he does that, we'll pay the fees, and then I'll have a permit, and we'll go ahead and schedule inspections.
Okay, so does April 1, do you think you'll have all that completed by April 1? Not the work, obtaining the permit.
Oh, yes.
Okay.
Only because I spoke to them today, and they said, maybe tomorrow, so,
Okay,
yes.
okay. And I assume, ma'am, you're the respondent, you're the property owner. Do you have anything that you'd like to add? If you wouldn't mind just coming, I have a couple of questions for you, easy questions, but,
Yeah.
and your name, please?
Majida Lutfi.
The city has requested the payment of its administrative costs, the amount of $219.66. It is their statutory right to request those, and outside of extraordinary circumstances, I will grant those. They've asked for that to be paid within 7 days. Do you have any hardship in paying that amount within 7 days?
Yeah.
Yes, you do, or yes, it's okay?
Yes, I do.
Okay. Yes, you're able to pay that in 7
Yes,
days? Okay.
yes.
Because I will often work with respondents if there is a hardship that makes that challenging, but you're okay?
Oh, okay. No, yes.
Okay. Do you have anything else you'd like me to hear?
Everything is clear for me.
Okay. Then, based on the evidence and testimony provided today, I will find in favor of the city, find the property is in violation for performing construction work without permits. I do find that they have made substantial headway in getting this resolved. It sounds like it will be resolved in short order. I will grant the city's request that the compliance date be set at April 1, 2022. If not brought into compliance by that date, I am going to lower the potential fine amount from your request, given the willingness to cooperate from the respondent, to $150 per day. So that's not a fine that you have to pay right now. It's not a fine hopefully you ever have to pay ever, but what that means
Yeah.
is on April 2nd, if that permit's not in hand, that fine starts to run. That's when that would kick in.
Okay.
And I am going to order that the respondent pay to the city the amount of $219.66, which amount is to cover the city's administrative costs in prosecuting the case. That amount shall be due within 7 days of the date of my written order. So it's not 7 days from today. You can pay it whenever you want to, but that clock starts to tick the date that I signed that order. So when you get
Okay.
it in the mail, that's what you want to pay attention to.
Okay,
Okay?
thank you.
Thank you.
Case number 2021-2659, Asset May Enterprise Corp., owner, location of violation 810 8th Street, St. Cloud, Florida.
Alex Miller again, presenting the case for the property located at 810 8th Street. At this time, I would like to enter into evidence the following items: copy of the notice of violation, copy of the notice of violation sent by certified mail, copy of the notice of violation sent by regular mail, posted at the property in City Hall, copy of the statement of violation and notice of hearing sent by certified mail, posted at the City Hall, copy of the PowerPoint presentation, affidavits of postings, evidence of mailings, copy of the code sections in violation, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $238.32. It's the same owner, different company.
Okay.
On December 2021, while speaking with the handyman working on the house located in the front lot at this location, Supervisor Sparkman and I observed that the house located in the rear lot was remodeled and did not find a permit on record with the city. 8 photos were taken.
Officer Miller, would you like to hand me the binder? I just realized
Oh,
you
sorry.
still have it. Thank you.
On December 21st, 2021, I received a call from the owner stating that she will allow us to do an inside inspection of the property, and the appointment was scheduled for December 29. On December 29, 2021, an inspection of the property was performed, and I was able to verify the plumbing, electrical, water heater replacement, windows, air conditioning, a porch, and a storage room addition were performed prior to obtaining a permit. After the inspection, I spoke with the owner and explained that a permit for all the work performed will need to be obtained. She stated that she had COVID and she will need extra time to obtain the permit, and 12 photos were taken. On December 30th, 2021, a notice of violation by regular mail was sent to the owner and agent to correct the violation within 7 working days. On January 14, I verified that not an application was submitted. I made contact with the owner, and she stated that she will contact the contractor and find out what's going on with the application. A notice of violation by certified mail was sent to the owner and agent to correct the violation within 7 working days. On January 25th, 2022, I received a call from the building department to let me know that they received a lien search request for this property. I made contact with the owner, and she confirms that she was trying to sell the property. I explained that she will need to obtain the proper permits prior to selling the property. On January 27, 2022, I verified that on January 20th, an incomplete application was submitted and a permit has not been obtained, and the property was still in violation. A notice of violation by regular mail was sent to the owner and agent to correct the violation within 7 working days. Posted the property in City Hall, did an affidavit of posting, and 1 photo was taken. On January 28th, I received a call from the contractor stating that he was trying to help the owner, that he needed extra time to obtain the permits. On February 28th, I verified that permit has not been obtained and the property was still in violation. A statement of violation and notice of hearing was sent to the owner and agent, posted the property in City Hall, did an affidavit of posting, and one photo was taken. On March 11, 2021, a reinspection was performed and verified that an email from the building department has been sent to the contractor requesting again that he provides the necessary paperwork to issue the permit, and the property was still in violation. As of today, the permit has not been issued, but I don't know if he knows anything different. It is the city's recommendation that the respondent be found in violation of construction and repairs and alterations at this property prior to obtaining a permit. The city will recommend that the respondent be given until April 1st, 2022 to obtain the permit, or a fine in the amount of $250 be assessed until compliance is met. The city will also request that the cost incurred in bringing this case before the magistrate in the amount of $238.32 to be paid within 7 days of the written order by the special magistrate. This concludes my presentation.
Thank you. Respondent?
I submitted both permits at the same time, 7/22. As of today, there was one department that's under review, so that should be done shortly also.
Okay, so same
It might be-
question.
It might
for
be
you.
like 2-3 days after 8th Street, but
Okay, so same question I had for you on the last case then. Do you think April 1 will present any problems for you?
yes.
You think April 1 will be a problem or will be okay?
No, it should be okay.
Okay.
I'm at the mercy of the building department.
I understand that, and as long as everything has been submitted correctly.
Yes, it
and-
has, as far as I know.
And as long as it's paid for and picked up, that's what you can control, but if something wasn't submitted correctly, and if you're 2 or 3 days behind the other one, you're pushing close to April 1.
Yeah.
Would you like a few extra days on this one?
If I can have a few extra days on 7/22, just in case it comes back for another reason.
What day of the week is April 1?
This is 8/10. This is 8/10. This is 8/10. This is 8/10.
The property that we're
discussing
is
8/10 right now.
And Monday would be.
8/10. This is 8th Street, this case.
Would be the 20,
Oh,
would be the 4th.
Okay,
Yeah,
8/10,
the 4th would be
well, I'm
the
good
Monday.
on,
You're okay on that?
yeah. I'm good on 8/10. It was 7/22 that came back with one remark.
Okay, so
I had
April
it
1
mixed-
is
I
fine
had it
on this
mixed up.
case.
Excuse me?
So April 1 is fine on this case. This one is actually ahead of the other one?
8/10, yeah, 8/10's ahead of 7/22, yes.
Okay. Oh, I'm looking at, that was the first one, okay.
I apologize.
All right, then I will, I'm sorry. Was there anything else you wanted me to hear?
Excuse me?
Was that it?
Yeah, that's it.
And anything, same answers you gave me in the last case to the questions I asked about the cost and any hardship? That I will find in favor of the city. I will order the violation be cured by April 1, 2022. If not brought into compliance by that date, a fine of $150 per day shall accrue. Order the respondent to pay the administrative cost in the amount of $238.22, which amount will be due within 7 days of the date of my written order. And that is my ruling on this case. I am going to go back, clerk, before you call the next case, I'm going to go back to 7/22. And I am going to give them, those few extra days there because
City understands. That's
I don't want a fine to start accruing because things just were a little bit slow in
City
processing.
understands. We just need the date for our records.
Yeah, I'm going to give an extra week on that
To
one.
the 8th of April?
Yes, sir.
Okay, sure.
Thank you.
Case number 2022-11, Spirit SPE Portfolio 2006-6 LLC owner, care of Ryan, Burger King tenant, location of violation to 24,013 Street, St. Cloud, Florida.
Pam Neal, City of St. Cloud Code Enforcement. They're in compliance, so I'm just going to null prosecute.
Okay.
Thank you.
Case number 2022-205, Sharon Rife, owner, location of violation 3446 Cypress Point Circle, St. Cloud, Florida.
Good afternoon, Melissa Howes, Code Enforcement Officer for the City of St. Cloud. I am presenting this case for the property located at 3446 Cypress Point Circle. At this time, I would like to enter into evidence the following items: a copy of the notice of violation sent by certified mail, posted on the property and City Hall, a copy of the statement of violation and notice of hearing sent by certified mail, posted on the property and City Hall, copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code sections in violation of, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $212.16. The respondent is not here. On February 2nd, 2022, during routine patrol, I observed 2 vehicles parked at this location that did not have current registration tags on them, and some of them had flat tires. This is a reoccurring violation at this location on the same exact vehicles. The property's been cited 7 times for the same violation since 2020. 10 photographs were taken. On February 4th, 2022, I sent out a notice of violation by certified mail to the owner of record. I posted the property in City Hall, did an affidavit of posting, and took 5 photographs. On February 17th, I spoke to the owner of the property, and she assured me that both the vehicles would be gone over the weekend. On Monday, February 21st, a reinspection was performed, and both vehicles were still in violation. 7 photos were taken. On February 22nd, 2022, I sent out a statement of violation and notice of hearing by certified mail, posted the property and City Hall, did an affidavit of posting, and took 2 photographs. On March 7th, a reinspection was performed. One of the vehicles was removed, but the other one was still in violation at this location. 2 photos were taken. On March 14th, another inspection was performed, and the red car is still in violation. 3 photos were taken. It is the city's recommendation that the respondent be found in violation of having abandoned vehicles at this location and not correcting the violation by the time specified. The city would like to give the respondent until March 31st, 2022 to correct the violation or pay a fine in the amount of $250 a day until compliance is met. The city would also request that the cost incurred in bringing this case before the magistrate in the amount of $212.16 be paid within 7 days of the written order by the special magistrate. And just so you, in case you ask, the $250 a day is because in 2013, the same property was found in violation of abandoned vehicles. And that concludes my presentation.
Thank you. Yeah, I had picked up in the recurring nature, so I was inclined to approve the 250 or order the 250. Have you had any conversation at all with the respondent?
The only one I had was when she said that both vehicles would be gone by the end of the weekend. My
she own
posting
the
is still in the yard. The one that was removed was hers. The other one was her daughter's, who supposedly lives out of state, so I don't know what's going on with that.
Okay. Based on the evidence testimony received, I'll find in favor of the city, find that the respondent is in violation of city code for allowing abandoned and disabled vehicles on the subject property. Order the respondent to cure the violation by March 31st, 2022. If not brought in compliance by that date, fine the amount of $250. And I am basing that fine amount on the recurring nature of the violation, the severity of the violation, and while some steps have been made to bring it into compliance, it has been going on for quite some time now, and I think that that is a reasonable amount in this case. Or also order the respondent to pay the administrative costs incurred by the city in the amount of $212.16, which amount will be due within 7 days of my order.
Thank you, sir.
Unfinished business, case number 2021-1258, Milagros Rivera, owner, location of violation 1718 Charleston Lane, St. Cloud, Florida.
Good afternoon, Jack Morrison for the City of St. Cloud. The respondent would like to address the magistrate. Code officer and staff are available for any information you might require.
Okay, thank you.
Hi, good afternoon. My name is Ada. Milagros, my sister. I'm helping her with the project. And I apologize, first of all, for the inconvenience that this caused to everyone. Sorry, thank you. I don't understand exactly where we are. I know I came here on December 15 for a hearing. My understanding is that everything is still pending, digital spending, pending reviews. So I don't know how we can move forward with the project. Not clear about a letter that it was sent to her for a fine for $250 a day for being non-compliance. So I'm not clear.
Okay, if you'll have a seat for 1 second, whoever from the city can let me know where we are in the city's end with the permitting, because I think that ultimately this is a permitting question, right?
Hi, Bob Deathridge, building official. The permits have been denied by both building and zoning. They do not meet setbacks, and they do not meet the minimum square footage for the mobile home on the property. So they cannot be approved the way they are. Mr. Stephen White with zoning also has some information for you.
Okay.
Afternoon, sir. Stephen White, planner with Community Development for the City of St. Cloud. In reference to the property, I did print up some information that I can bring to you to look at and explain it to you.
Can it go into the record? Can I hand it to the clerk and she can keep it? Okay.
On this one, this is what was submitted for a zoning review, and I highlighted the rear setbacks of the property, which is showing it at 19 feet 11 inches. For the zoning district with that property of MHA for mobile home annexation is 25 feet. So the structure that they're trying to attach does not meet the setbacks. And also in the land development code, it was denied for section 3.20.18.2D. And it states structures with non-conforming setbacks may expand, but not create another non-conforming aspect. And the building already being non-conforming with the size under the 700 square foot minimum size, they're now creating another non-conformity by not meeting the setbacks of the addition to bring it into conforming to today's code.
Okay. Anything else? Ma'am, if you'll come back up.
Okay.
Do you understand what both of them just said? Do you understand
To some degree.
the implications of
To
that?
some degree, like the new structure does not meet either the specification for the addition.
Correct. It does not meet the zoning code.
Okay, so I don't understand because from the very beginning, I did try to do everything the right way. Before I even brought the structure, I had it, the building department told me that I needed to have it approved by an architect. And if the architect will do whatever it was necessary, then I will bring it in, that they will look at it and approve it. It was approved. Everything I've done with this property is trying to be in compliance. I understood after the mobile home was brought in and set in anchor that it was too small and it needed about 300 square feet added on because it was too small. So that's why we tried to brought in the new structure. And so what's there, I have tried to work and get the permit. I've gone to the architect. I've tried to be in compliance and bring everything that I need. At this point, if it's still not enough or it's not, I don't know how to say it, maybe workable, I still don't think that she should be penalized, $250 a day for
Do you remember the last hearing that we had on this?
Yes.
I do too. And I remember the case being made by you and your sister at that hearing was to give more time to try to work on these permitting issues.
Right.
And do you remember me saying at that hearing, I'm going to give you that time?
Yes, you did.
I can't promise you that you're going to be able to get these permits, and if you don't get the permits, you're going to have to remove it. Do you remember that?
Exactly. I do remember that. Yes, I do. And I have looked on the system for the contractor, and he said that everything, was still being worked, that the paperwork was being submitted, new applications, and he's gone to the architect for the roof. I mean, he done all his part and submitted, and everything says still digital pending, which let me and my sister have hope that, yes, that we're going to continue.
Okay. Do you understand that based on the city's testimony from the building and planning department, that as it's configured, that mobile home cannot stay there?
Okay, the mobile home and the structure.
Do you understand that? That's effectively what they are saying, is it is not going to be able to be permitted in its current location, in its current configuration, and the work is not going to be able to be permitted.
Are we talking just about the mobile home or the structure itself, or both?
They're both involved.
Okay.
It's all rolled together, because the mobile home, it sounds like, is undersized, which the violation in this case, if I remember right, it was for the work without permits, correct? But so I'm not entering an order based on the mobile home. I am entering an order based on the work done without permits, or I have already entered an order based on the work done without permits.
But what permit? Because it's been a permit pool for, the work that's been done.
The construction work.
Okay, for the new structure.
Correct. I mean, that is what, I'm remembering this case right. That is what this case was about.
So I'm just going to tell you a little history. So when she applied for the permit back in 2018, during the review, she was advised that the mobile home that she was trying to put was too small, so the permit was denied by planning and zoning. So when she submitted a revision and said she was going to install a 700 square feet home, the permit was approved and it was issued. So she installed the mobile home, the 399 square feet home, on the property after she was advised that that's not allowed. She submitted a permit to have the unit added the square footage. Building and planning and zoning tried to work with her, and they gave her a permit for the residential alteration, but the permit's expired twice. So when she tried to obtain the permits again, she was issued the permits, and she had to complete the work with a final inspection approved within 90 days. She didn't do that. So now the permits are disapproved again, and that's something that is not allowed because she did it all the wrong way. She had the handyman working, she never had a contractor working on the property. I mean, it's just...
He was a contractor. It's been very complicated, the whole situation.
I appreciate the background and the refresher on the facts, but who did what at this point is not where my focus is in this case.
All right.
And I asked you the question that I did for a reason, because at the last hearing, you heard many of the same testimony from the city, much the same history. They were saying then that they did not think that you were going to be able to get those permits. I gave you the time to try. I hear what you're saying, that you were holding on to hope that somehow they might issue. And
Because it says digital pending, even up until this morning, I called the front office, and they looked up and they say, yes, it still says digital pending review.
well, you now know that they have been denied. And you now know the reason they have been denied, and it does not sound to me like it's a curable, at least again, in the current configuration, that you're going to be able to do what you are trying to accomplish. So I don't know if it can be moved on the site. I don't know, and that's neither here nor there for me. I can't enter an order on that. But what I do have in front of me is a case where I entered an order, we talked about this, and you did not comply with my order. That order gave a time by which certain things were going to be done. If I could
Can
get
I
you,
say
you don't have to sit, if you just take a couple steps to the side, I want to ask the city attorney a question. The digital pending is what gives me some pause on the fine accrual. And I also am trying to think of a way of getting this case to compliance. And I don't know, the running fine at this point, I have a sense, may not motivate things to move faster. I think I can do that or encourage that by actually abating the fines that have accrued thus far and abating it somewhere, and I'm going to ask some more questions to figure out how much time is needed.
To a point certain.
To somewhere, to give them a little bit more time, that if they comply by that date, that then I would not impose any fines. Because the digital pending, the confusion, I think there's at least good faith in the presentation of the argument of that. Whether it's, some people might look at that and have done other things, but I do believe it's being made to me in good faith.
I am not in a position to certainly contest your assessment of that. Nor am I in a position to accept agreement to it.
I'm not asking for your permission,
But
but I
yes.
did want to give you an opportunity to tell me that you think I'm wrong.
I'm not in a position, I understand the reasoning that you have from legal perspective. I'm not in a position to accept that from the city, but would understand it and would go forward. As always been stated, the city's objective is compliance. So
Okay.
as long as it's within a reasonable period of time, because this has a bit of history as you've heard.
Okay. And ma'am, now I'm going to ask you the same question. So trying to break this down into non-lawyer language, what I am contemplating here, I understand your position that the fines started running, I believe it was February 1, correct?
Yes.
The fines started to accrue. That amount gets to be very expensive very quickly. I do believe that you are presenting, that your testimony, that you were checking the site and seeing that it was digitally pending. You were still waiting for some indication that it had been disapproved. So I don't think you were acting in bad faith, but from my perspective, this has come to the point where the code enforcement or the code violation has to be resolved. And it looks like you have exhausted your effort, your opportunities regarding trying to get what's there permitted. So now we are to the point that we talked about at the last hearing where this may come down to you're going to have to remove it. And there is a path to curing the violation, and at this point that is removal. How much time do you need to accomplish that? And it's important that you ask for a reasonable time, reasonable to the city time, because if you ask me for, I'm going to be extreme here, if you ask me for 2 years, I'm not going to take it kindly. So how fast can you have it removed?
I don't know, 90 days?
Any response from the city on 90 days? Okay. Do you have anything else you'd like me to hear before I make a ruling? Okay. So, back to, again, explaining some of the lawyer language, what I was telling the city attorney and what I'm now telling you, I am going to enter an order today abating the code enforcement violations that have accrued. So I will withdraw the order imposing fines. They timely filed the request for hearing.
Just for clarification, I don't mean to interrupt, but you're abating the fine, but the violations as were determined.
I am not doing anything with the original findings of fact. This is still, the original violation is still the original violation.
Just the consequence thereof. Okay.
Correct. And so the order that I'm talking about now is the order imposing fines. The request for appeal was timely received, so it is still within my jurisdiction to modify that order. That's what I was figuring. Wait a second, do I still have the authority to modify that order? But the appeal was timely filed. A request for rehearing was timely filed. And so I am going to abate those fines. for a period of 90 days from the date that that order is signed, which is going to be sometime middle of next week. So you'll have 90 days plus a few. But if it is not brought into compliance within that time, I will impose all of the fines that have accrued since February 1 to this date and to wherever we are in the future. So I'm not wiping the slate clean. I'm giving you an opportunity to get this taken care of. And if it's not taken care of in that 90 days, then all of those fines are going to be imposed. Okay?
Thank you.
Okay. Anything else? Do you understand? You'll have it in writing, but do you understand do you understand my ruling? Okay. Okay, thank you.
New business, none. Next scheduled meeting, April 20th, 2022.
Anything else from the city? Anything else from the clerk?
Nope.
We are adjourned. Thank you, everybody.